Yes.
Seeing as though Tim wants to be in on this call, I'm recording it for his sake.
Cool. My question was, what is the, I had two questions, but what is the statute that says they can't ask for a particular species of money, if that is available?
That has, it doesn't have anything to do with equity, but and the particular statute, it just depends on what you're looking for. But really just read anything Title 12 Banks and Banking, Title 31, joint
That's
resolution.
Title
Yeah,
31.
the joint resolution from Congress that speaks kind of about it too. So, but yeah. Morgan, I know you had a few questions as well. Tim, I think I saw you in there asking some as well about it.
Wrong, Tim. It was Tim Forbes. But he's now.
Well, I have a question then.
Oh, okay. This one does.
What's the meaning of life? It was a joke. I'm sorry. I couldn't resist myself.
It's equity.
It was a different Tim, but
yeah, I figured.
JD, do you have any books you would recommend?
The equity, just do like Exclusive Equity Jurisprudence, Suits and Chancery by Henry Gibson, just for like the principles on equity. There's a lot of different ones. American Jurisprudence, all the editions are good.
Right.
The problem with those is it really just does teach you principles in equity. It teaches you how to kind of move in court, but if you don't have that understanding of the definitions of each thing that they're using, it is a tough read, because it's really just process. But
yeah, I was going back to the equity, and I know what we was talking about. I reviewed those books, and like I said, because they are a very hard read, particularly when you don't know. The principles are good, but when you're going into that situation, they're going to flip it so many different directions. It seems futile to use equity. And what I was talking about, the merger of the equity with the law, and then they're playing admiralty equity, which is whatever the judge say is equity.
Well, that's the point. That's not how equity works. It's not whatever the judge says is equity. There's no such thing as equity admiralty. There's no those things. That's not a thing. So equity is what you bring to the court. Article 3 courts, Article 3 judges are equity judges, and all that means is like you get your case bumped from an Article 1 or Article 2 court up into that Article 3 court. They're going to be like, "What are you here for?" This is just a base level explanation.
Or is that just any court with a judge that says he's going to act equitably?
The judge is not going to say he's going to act equitably. That doesn't happen. That's not how it works. Right? You bring equity. All judges must have equity before their eyes.
You went out.
So
We
bring
can hear
it
you.
to the court. Can you hear me?
I can hear you.
Yeah, I was gonna say I feel like I'm.
Yes, I went out. I got to go back and come back in. Sorry. Can't hear.
Yeah, so basically, I agree with JD. It is how you present your case that you're going to get equity, because these judges they're both in at law and equity, these Article 3 judges. So you have to bring equity into the case for them to see it and do equity.
Right.
You can't just say, I want equity. Your case has to be built in such a way to establish equity, both you giving equity and receiving equity.
Okay, but aren't there some different terms that would, if my perception is, and this is the church would be equity, unless it's talking about property or whatever, then you go into law. My situation is a situation that happened in the church. Then we go in with the ecclesiastical abstination doctrine, which is actually the separation of church and state.
Okay, here, slow down, right?
Sorry.
So let's start back. So it's not, what about the church do you think is equity versus like a property conversation that would turn to law? So explain what you think that is, and that'll probably help you get a better understanding. So what do you think the differentiation is?
My thought was that the church was operating on a moral perspective, and the courts were operating on the legal perspective.
Okay, so the point is, you want the court to operate on a moral perspective. That's what equity is. But you have to do it through private process. Your paperwork has to state that, in so many ways, in so many words, because equity is not about the form, it's about the substance. And that's why I say that, because you could literally write on a napkin, what it is that you need to get across, and that will suffice. That's substance, right? That's not form. And in court, a very base model, like elementary example, is simply, I shouldn't be in this courtroom, right? If this court is not a court of equity, I shouldn't be here. My equitable rights are endangered here. I declare that this is damaging to my rights in the private, because that's the whole point. I'm in the private. Equity states that I shouldn't be talking to anybody but a chancellor, right? An Article 3 judge.
Thank you. Oh my goodness. That I've been waiting to hear that. Thank you.
Yeah, but there's a way to get that across to the judge. So the point is, quote unquote, in common law, right? Common law is like, show me the complainant, show me the injured party, and all this other stuff. That's common law. But equity means you don't have to go in and play that game with them. I don't have to play the name game. I don't have to do any of that stuff, because it's about the substance. It's about morality, right? So you want the judge to understand that from a moral standpoint, how to communicate with you. So now, don't get me wrong. There is things that you have to say, but it's also about how you file. So if you're talking about filing a motion with the court, that's not equity. You can't move the court to do anything. So you can't file a motion. We're not lawyers. We're not pro se. We're sui juris. So the thing about that, it's like that. So when I file a petition with the court, I'm not filing a complaint. I'm filing a bill in equity. That's equity, right? So we're discussing why I shouldn't be talking to this court right now. I can't be here.
Ooh, man, you sound like Jesus right now, man. You have no idea, because I've been looking for that, and I've heard pieces of it, and everyone says in the Chancellor books. I mean, I've been in it for a while, and I've been doing this for 7 years, and not heard what you just said.
Right, and you could do so. I mean, listen to it like this. So you brought up the church. So if you brought God's law into court, that's equity, right? So you'll hear a lot of people, state nationalists or whatever, say that the law doesn't apply to them, or you have people outside who think that you're a sovereign citizen and that the law doesn't apply to you. Well, in the Bible, what does it say about the law? The law is for whoremongers and lawbreakers, right? For thieves, murderers of women and men, murderers of mothers. That's what the law is for, right? So I shouldn't be in here. I didn't do any of that stuff.
Yeah, that's 1 Timothy 9 through 10. So knowing that the law is not made for a righteous man, but for the lawless and the disobedient, for the ungodly and for the sinners, for unholy and profane, for murderers of fathers and murderers of mothers, for manslayers, for whoremongers, for they that defile themselves with mankind, for manstealers, for liars, for perjured persons, and if there be any other thing that is contrary to sound doctrine.
Wow.
Exactly.
What is that again?
I was reading that today, and I was going to post that.
That's good. 1 Timothy what? I'm writing this down.
1 Timothy 1, 9 through 10.
1 Timothy 1, 9 through 10. And that is how, so you see how we just used the Bible to basically say, where's the injured party? That's what I just used the Bible to say. That's equity.
Yep. Actually, go 8 through 10, because 8 says, "But we know that the law is good if a man use it lawfully."
Correct.
Woo, that's so good right
So
there.
now what you just did was, by saying that, you just got rid of the Trading with the Enemies Act, right?
Yep.
So I don't think that I'm a sovereign citizen,
Yep.
whatever that oxymoron is, right? I'm a friend of the court,
Yep.
right? So I need the court to help me settle this matter. That's all equity is.
And it also helps if you try to settle it privately with the person and keep
Right.
record of that. And if they don't come to an agreement, it's like I come to my brother on my own and I air out my grievances. If he doesn't accept that, or if he ignores it, then I go with another person. And if that they still don't accept it, I go and take him before the church. So we're doing the same thing, but we're using law. We're taking them before the court because we've attempted multiple times to try to settle the differences, and they won't come to an agreement. They won't come to a
Exactly.
compromise.
So it's mediation, right? So somebody asked me about family law. I think Morgan was the one asking me about the family courts and things like that. They try to order you to come and perform at that venue. But what you just heard her say, basically one of my risks that I do in court, especially because I'm in family court, because that's where I am a lot, it has something to do with that, right? So if there's an issue between her and I, it'll be handled privately between her and I, the two people that are party to the contract, right? The real party in interest is not here today in the court. So, we can't have this discussion anyway. You're not party to it. This is between her and I. So we'll handle it privately as a civil matter. And anything that happens it's an agreement between the both of us. Nothing can change in this contract unless we both say so. And we don't need you to help us with that. That's how family law is, right? So that's something that her and I have to handle privately. I didn't ask to come here. There's no controversy. Contract, there's no breach of contract, right? So if your child isn't harmed or in a bad way, then there's no controversy before the court. Simple as that. In family law, I haven't harmed my kids. She hasn't harmed my kid. I know she's petitioning the court, but you guys, it's your job as administrator to say, no, we can't see that. There's no controversy before us. We can't hear that. You got to handle that with him. So same thing. You need to do everything you can before court, which is why they have mediation, right? You'll have somebody come in and sit with you and, hey, can we hash this out? Then you go to court and you certify your agreement on the record. But you're supposed to do that for yourselves. You're not supposed to do that in court. And that applies to all court dealings because all court dealings should stem from a contract. That's why everything is civil in court, not criminal. Somebody filed a claim on you in the private. So when you guys are saying, show me the injured party, it's really, I want to see the contract that I breached. And if there's a contract, then myself and the other parties of the contract will handle it privately. We don't need the court. So equity just speaks to letting them know. That's why we do abatements, because you're letting them know I'm not somebody subject to the court. I can handle this on my own outside of court. And we can use God's law. That's why we do testimonies under God. We don't do affidavits because you want it to be clear, and everything needs to be entered into the record or entered into evidence. That needs to be stated clearly. But yeah, I use God's law in all dealings with family court. I'll put Bible scriptures in there before I put anything USC code or any US codes or case law or anything like that. I'm putting Bible verses. So yeah.
And that's exactly what I was trying to do. Unfortunately, I wasn't versed on it enough because, you're talking about Matthew 5:25. Go to your brother in private. That's what it is? I think that's Matthew 5:25 or Matthew 6:33. 6:33 is seek ye first. But I was trying to do that with the church members. They went to the court, and I wasn't versed in that. And then so to counter, we got a lawyer, which just sent the whole thing down the drain. And we
Yeah.
lose because whoever makes the claim normally wins.
Well, I mean, you lose because you argue. That's
Right.
why you lose. You have a lawyer for one, but then you argue. So that's why you lose. In a civil claim, if you don't know anything at all, the last thing you do is speak. Don't argue. Don't even address whatever their concerns are. We don't have a controversy. I don't need to be here. So a lot of the time, that's where you run into those issues. And again, I'm not like bringing religion into the court. I'm bringing God's law into the court, right? So there's a difference, even with the church, because the church is against the Bible, right? Having a church, period, it goes against the Bible. It has nothing to do with God at all, the church. So that's tax exemption. It's not, that don't have anything to do with the Bible. So even in those dealings, it's about morality. All dealings in equity are about morality, but you still have to know how to state your position. So you hear Pastor talk a lot about not being a surety, and then you heard me rebut that with, you're always the implied surety. It doesn't matter what you're doing, you are currently acting as implied surety for all deals happening in the public. So when you go into court, that's how you're doing that. You know, that's what a special appearance is before court, and then in court. That's one way to state your position. It's one way. Granting your name to the court on special deposit for future return with your interest, and then coming in as implied surety. So on special appearance as implied surety on behalf of the principal debtor to settle and close this account or settle the matter. That's usually how you start that off. And then, like I said, there's a lot more to it if you have a judge that pushes buttons and things like that. But everything is pretty much based in trust, right? That's why they can't deal with you. Everything is in trust. Even if you don't have your private trust done, it's still about trust. But it's good to have a trust, because then when you're speaking this stuff, it's actually for your private trust, which is what I have for my daughter and myself. I tried to include the mother of my child in it, but she's doing a lot of things that would open my trust up to exposure. So I can't very well add her to it. But in nature, she is the natural grantor, right? She's the grantor of life to my daughter. So I did want her there, but to each their own, I suppose.
Man, that's so. I've heard that it is possible to go back, and I'm talking about 5 years going back, trying to get this thing rectified. Is that in the cards?
Well, I mean, I guess it just depends on what it is that you're what you're trying to do, because in a fraudulent contract, there's no stop shouting.
Never was a meeting of the minds on a fraudulent contract.
Well, if you never had one, then that's what makes the contract fraudulent, right? So if you guys weren't at arm's length, and there wasn't full disclosure in a contract, then there's no contract at all, especially in a bilateral contract. But you can always go back. There's no statute of limitations on fraud.
See, I've heard that, but they have a statute of limitation on their fraud. But it's just like, I guess, sin. There's no statute of limitation on sin till you repent.
Well, that's exactly what it is, though, right? Yeah. As a
Yeah,
sinner, you
but
can always repent.
Al,
Yes, sir.
the statute of limitation does not kick in until you are
Until you
convicted of
know.
the sin.
Right.
Until you realize what it is, that's when the statute of limitations kicks in, if there is one.
Right.
Nice. Thank you.
That's why you can appeal any court case. One of the reasons is, undiscovered evidence. You just found new evidence. It don't matter if it's 30 years from now. Look how many times convictions get overturned because of new evidence. How you doing, JD?
I'm doing great. Good to hear your voice.
That this morning that you commented to, that wasn't directed at you, man. That was directed at those people. That was directed at these people that think when they go to court, they think they're going into equity, and equity is all there is. No, there's other parts. Equity kicks in a lot of times when there is no law that offers a remedy. So equity will kick in then. But I've read too many court cases that says the process is basically equity. You are giving equity. the remedy as is at law.
Right, exactly. And that's what I'm trying to get people to understand, that they make it sound like it's hard to discuss. One, I don't like typing anyway, but it's just hard to discuss as what they bring it as or present it as. They try to present it as like a means. You know what I mean? Like it's something, a weapon that you can take off of your tool belt, as far as it, when it's really the tool belt. Equity is the tool belt itself. It's not a weapon you pull from it. So
exactly.
So yeah, I knew you weren't talking to me. But like I said, I know Morgan was having some issue with family court. I really didn't get the whole story behind it. I know he typed it in there, but I couldn't really pick up the full situation. But like I said, in family court is really just, they're not party to the contract, and the contract is the original conception, which is the original trust established. They weren't there for it. They can't administrate that, not without your permission anyway. So I know everybody has their own ways of doing things, but equity is just about morality, substance.
Yeah.
You're not mom or dad, so mind your business.
When you start realizing really what they're administering, when they take you to court, say CPS, and they're going after the child, what is the child? It's not your offspring. You go in there and agree to that being the name, but if you actually go through the different birth documents and all the records, the baby never got named. Can they prove that's the name of the offspring? No, they can't, because they have no firsthand knowledge. But you agree to their terms. You agree to their terms, and now they can take your kid.
Right. The simple fact that you're in there arguing is part of the reason that they can do that too. You're in there over a controversy that there isn't. I don't have a controversy with CPS. You're not going to take my kid. There's no controversy. But like I said, I deal more with when there's a parent against a parent, because I always tell people the goal is never, you should never be in there. One, they make it a controversy because they pin you guys against each other, but also you go in there, if you're not using words like our, right? I say our daughter when I'm in there, right? Our baby. When I speak about the things that I'm doing, everything that I do is with the mother of my child. Nothing is against the mother of my child, even though we don't have a great relationship. We were both there for the birth, the trust established. We were both there for the conception, right? So that's the original trust established. So that's the only person I care to deal with in this matter. So if she hires a lawyer, that means she's disabled anyway. And like you said, in the law of agency, he can never exceed the status of who he's there for, the principal. So
if she is an infant, and he can only act as an infant, he can't act like he can't testify.
Right. And that's the point. So, in court, it's not a big deal as people make it, but you definitely shouldn't go in there and be adversarial with the mother or father of your child or baby, because that's what the court wants. That's why you're there, because of that controversy. So for me, I simply state there's no controversy. This will be handled privately between myself and her. And then, of course, there's a lot more stuff that I say, because judges don't just let you walk out. But, it's not a huge deal. But I was just reading that stuff. People were thinking what their approach was to equity, and it was irritating me. So.
Oh yeah, I don't doubt that.
Yes.
Can I give you like a brief synopsis to kind of give you an idea of my personal situation?
Yeah, go ahead.
So my son was born in withdrawal. His mother is just a heavily addicted person, and I wasn't aware of that in the beginning. And his whole little life, so he lived in a rehab facility by age 1. DHS and social services were involved by 1.5. By 2.5, she abandoned. And then after a couple break-ins, I petitioned the court because the police said I had no legal rights because I wasn't a married father. So I petitioned the courts. And the first 2 years of courts, it was just a lot of crime and incarceration and active addiction. But the first law firm I had intentionally made me wait and advocated for her and then quit whenever they told me I was signing sole custody, but it ended up being joint custody while she was incarcerated. I was able to not be held to that since there wasn't a signature. I went to trial with another law firm and they omitted evidence without telling me. So the court was kind of uninformed to the severity of the child's life. And then they gave her a recovery center, which is her seventh, to reduce the felonies and misdemeanors and things. And so essentially it didn't end supposedly until he was 5, and now he's 6, and I'm still in court. But the judge has already advocated very strongly for her and made a predetermination of alternating weeks, and they still call it a paternity case. And I've gone into court and I've said that there's no controversy because I've offered for the mother to, see the child every day if she wanted, just as long as, the correct thing, the outcome happens, of him being raised and having a permanent home. But I facilitate a relationship, open phone calls. I'm not against anybody. I'm just for him. But the courts, the judge themselves keeps moving the court to up the visitation till they get to the alternating weeks. And in the little contract that we have, the opposing counsel has been in bad faith throughout it. I mean, I haven't even gotten proper service through things, copies of motions that they filed, and then they've been in breach of contract. And the judge has made orders for drug tests and different things, and none of those have been turned in. But the judge keeps in court themselves. And I've stated verbatim, there is no controversy. I'm open to everyday visitation if that's one relationship with the child. I'm not here to be against the mother because that is our child. I just know what's the most beneficial thing for this child. But yet they keep moving it and then don't read my filings, which I'm doing the same thing. I'm putting scripture, showing the importance of a father and what is beneficial to this child while still facilitating a relationship. But everything I'm trying, it either doesn't get read or it's ignored, and it just keeps on going until they get to that determination that they wanted. And so I'm not sure, without arguing, how to navigate.
So what are you establishing? What are you establishing in court, right? What position are you stating? What position are you stating in the actual hearings? Because one, it just sounds like to me that they're administering your estate without your consent. That's the start of it, right? So you don't have any powers here to administer my estate here. Now, what we're talking about is a contract, right? That they're not party to. So you're arguing. One, you're showing up to court. So that's the controversy there, right? So now we're discussing with the court. What you're doing is you're giving them. It's kind of a form of tacit acquiescence. So when you show up to this court and argue whether or not and how much or how little visitation is going to happen, that's you participating in negotiations on a contract they're not party to, right? So again, that's between you and the mother of your child. Whatever you want to do, you talk to her about it. Do you have counsel?
Not anymore. It was the worst thing that could have happened. I just now did a filing, a special appearance in excess jurisdiction, and so I'm starting to question these things. I'm fixing to do, but I'm sui juris pro persona is kind of what I'm putting in my filings.
And you've only started just recently filing as that?
Yes.
Okay. Did you get? Because you did have counsel. So you fired counsel, and then they're aware of that?
Yes, the counsel actually withdrew because trying to do things against what I wanted, and then they just quit.
Okay.
Now let me ask you something. You said the judge was advocating for the mother. Did he specifically say that, and is it in the transcripts?
Yes, sir. Yes, sir.
Okay. Well, affidavit of prejudice.
Where this is his mother, and there will be far more visitation than what currently it is. And right now, we will not. It's not right to do alternating weeks. And then they left it at that. And then also said contradictory language saying that this is a lifelong battle and it'll be even harder after graduation. But once graduated, they've not acknowledged and just have updated, because in the contract itself it says they've made it an interlocutory order, the language within the final order, saying anyone can motion at any time for visitation hearings, and rather than any motions from opposing counsel, the judge and upgraded each time to get to that predetermined visitation schedule that is in the transcript. So there's advocacy for is his mother, what the end result will be, which will be alternating weeks. And I've been raising the child since they were 1, and then so their intent is to then remove him from his stable environment and introduce him back into an environment that isn't really safe.
Yeah. So you just have to, like I told you, the goal is for equal time between both of you. That's what they're trying to establish on the record. So I would go and do a private contract with the mother, right, where it states that she can come and see him as much as she wants at your abode. It's not something where there's going to go over there or things like that, because access to the child is what is wanted and needed. They're trying to establish something on the record because you guys keep going in there and giving him controversy. You should do a trust. You should get a private trust specifically because of the situation you're in. And then that will, with the stuff that you're putting in, that will keep them out of it. Because right now they're literally administering your estate without your consent. That's what they're doing. So they're handling your affairs for you because they've assumed that you can't.
And that's a hardship, is because I've approached the mother and I've even told her, I said, anytime you want to visit him, take him to do whatever, just let me get a heads up, so I can clear our schedule and I can accommodate that.
Right.
But truly, it's a situation where her disdain for me surpasses her affinity for the child.
Okay. Well, then, I mean, like I said, you're still going for equal, right? So it's at this point, you want the court to know, if you're going to keep going, that you want it to be equal between you and her, because they're saying alternating weeks. You can, my split, I have my daughter Sunday to Thursday. She goes with her mother Friday to Sunday. So we split it by hours. I'm not splitting alternating weeks, but it's still equal on both portions. She still gets to see both of us an equal amount of time per week. I'm not going to split it out further than that because it doesn't make sense. But that was something that I told the mother of my child we were going to be doing. We had that discussion privately before we ever went to court. We only went to court to certify my agreement with her, on the record. So now every time she petitions the court with some BS, the problem is I've been making the judge the trustee, so they just keep switching the judge, right? Fire that judge, bring a new one, and I have to redo my paper. So you make the court the trustee to settle the matter. And then, like I said, it's the way you put your paperwork in, and then in the hearing, for you specifically, I can send you some stuff to say, but I'll show you where to learn it from it too, so you know what you're saying. But they can't actually. There's nothing they can do. This is about equity, so this is a moral thing. Family courts can't really do anything about a moral situation like this because you're not in there arguing that she can't see the child, so there is no controversy, like you said. They're advocating for her because she's a ward of the state. She can't handle her own affairs, right? She literally can't. She's disabled in a bunch of different ways, so they're trying to administer for her. But you need to get rid of that lawyer on her end, and you need to establish that you shouldn't be there, right? This is damaging to your rights in the private, and it needs to be moved to a court where they can see equity or dismissed altogether. But if you guys have
my issues.
Go ahead.
So I was awarded sole custody because at the time of trial, 2.5 years into the court case, I had trial and I was given sole custody only because she was still active. But they really intended to, if not for her active addiction.
So that's what I'm telling you. That's what I'm telling you. The reason that they can keep coming at you like this is because even in equity, the goal is equality, right? That's what equity is. It's equality. So they can't fight you right now because she does. I mean, right, assuming that she's just a woman by herself, she does have at least that. And equity, as far as equity goes, she's the grantor, so she does have rights to half of whatever it is. So on order, you have an order that's really unconstitutional right now. That's what I'm trying to tell you. So the order states that you have sole custody, meaning you have more time, or she has visitation, when, you know, her rights to liberty, to you know, to be free on her own, means that she can have just as much time with the baby as you can. So that's the only reason they can keep forcing you back into court, because that order is unconstitutional. They can't tell her she has less time with the baby than you do. So that's what they're using against you, is the order. So if you would like to do another contract, right, you know, with her, and let her know what you're trying to do, I was, like I'm saying, do it outside of the court, come back in with that contract notarized, you know, get 2 notaries on it even if you want to, and then really you're just certifying on the court. So her and I came to an agreement. This is our agreement. We're certifying it with the court, and this is what it's going to be. The only reason that they can even do what they're doing is because originally that's just not a constitutional order. They can't do that to her. That's what equity is too, unfortunately. So there are ways to keep her out of it, but like I said, you can do a trust, which kind of does, you know, give you a little bit of push with it. But as far as the court is concerned, the order you have on file, it's just not, it's not right. So that's why they're doing that.
And their intent now that they've told to the court, the opposing counsel, is to modify custody and go for full custody and have me on visitation, and are more so being accommodated because, as you said, the mother is seen as having, you know, more rights,
right?
Somewhat.
What state
and
are you
so
in?
Oklahoma.
Oh, okay, I feel like the only caveman family law court is Georgia still, but because I'm like I said, I'm in Nevada. The West Coast isn't like that anymore. Mother doesn't have more rights than the father over here. So I don't know how it is in Oklahoma right now, but she literally can't have more rights than you. That's just not how it goes. So they would never, even the court that's doing what they're doing to you right now, would never turn around and allow her to have, you know, more of, you know, especially if you're there speaking on behalf. But like I said, it's really just all about paperwork. Equity is about private paperwork. So I can get you some stuff, like we could probably do an abatement with the court. Now that you're operating sui juris, we can do an abatement, maybe even a writ of discovery with the court, or quo warranto. Either way, it doesn't matter. We can go either way with it, but they don't even have.
Now, I've considered the quo warranto as well.
Yeah, it's just about how it's composed. That's all.
And the issue I'm running into, because I try to be extremely civil for the better of my son.
Yeah.
Because I feel like it's really appropriate for him to see me show love to his mother despite her actions, and then when he's older, he'll understand. So I tell him, you know, if you wanted to live over there, I would accommodate that. If you want to spend the night, I'll let you. There's no issue. It's whatever you want. And he tells me, I don't want to live over there, Dad, but I really like my visits because he has a lot of fun. So I accommodate visits, and I tell his mother this, but her intention is to have him, you know, living there. And she speaks to him in that manner, which causes him his own little controversy.
Right.
And so it's me trying to advocate for what he wants when she's more so advocating for what she wants. And then that's where I'm running into the impasse, because there's not this co-parent situation in the way it should be. It's more so I have something of hers, and she wants it back, kind of thing. But the way his life is, she never actually wanted it. So again, it's for me rather than this affinity for the child, and that's where I keep running into a roadblock and don't know how to navigate.
Yeah, for me, and again, we're just talking about the situation. So for me, when that was happening, because that was happening, I made it very clear to her that it was going to be like that. But we have an agreement in place too. So even with the agreement in place, I still was like, if it's going to be a controversy like this every time I try and co-parent with you, she will stay here with me, and then you can come over whenever you want. You're anytime. Literally, just call before you come, so you know I'm here. But you can come over whenever you want. But she'll stay here, you know, until you and I are done with whatever this controversy is you're trying to create. Because what that does is it forces her to have to sit down and talk with you. Now she has a lawyer. So like I said, you need to send these same paperwork to that lawyer because, again, he can't really exceed the status of his principal, which is her. So he can't talk in there either. There really shouldn't be nothing going on in that court.
Now, I know the thing is that he said if it's in the transcripts, if you've got transcripts where the judge said he was advocating for the mother, if he said it that way, or even close to that, and used the word advocating, that can be used as him showing he was biased against you.
Right.
And I have I've illustrated all the evidence and compiled all the documents to show that. I just haven't been able to purchase its transcripts. They want almost $400 of the transcript.
Well, don't do that. Go down and listen to the freaking court hearing.
Mm-hmm.
Okay. Take your notepad, and when you hear something that you don't don't sound right, you write down at what
At what
2
time?
minute,
Yep.
2 minute. Yeah. You also do this in court. In court, when you're sitting there in court, and the judge says something you don't like, or the attorney says something you don't like, look at the clock, write down the time.
Mm-hmm. That's why you
And then,
bring notaries in with you. If you have friends that are notaries, they can bring them in and sit in on the case, and they can do it.
yeah, and then that way, when you say, I don't need the whole transcript. I need the transcript at this point. These are just the pages I need. That makes the difference between you being charged $400 and $50.
Right.
Okay.
Because if you get it in the transcripts, the judge clearly, in context, says he's advocating for the mother, that could be enough to throw the whole thing out and have to start over, because now you can show he's biased.
Right.
Yeah, I got that in one of mine. In actuality, where the judge was actually saying, "We have a victim, and we're trying to get on with this." So when she says "we," who is she talking about? You know.
Now, you may not be able to use this, I don't know, because it's not in your district, but here I'll give you some it mentions the term judge was advocating for someone, okay? And it doesn't say much. I'm going to tell you what, just that phrase alone is difficult to find anything
Hey,
in
look up
case law.
Judge was championing the case. That's one I found.
Send me that in a message.
Okay.
Judge was championing. That's a weird word.
She championed, CHAMP, like she championed. That was the only one I found where they ever had that, where it said a biased judge, championed the case for the prosecutor. You know that's legal talk. Who says championed? It's champion with an ED on it. And that's in some of my pleadings, actually, that I have that down.
Yeah, I'm not finding anything. You're going to have to send me the exact quote that you got it from. I found me a baby rice cooker yesterday for me to cook soup in.
Watch out now.
I know. I just had some soup. I had to stop and eat.
Yeah, I heard you were back on the road. I'm glad to hear
Yep.
that.
Yeah, me too. I was not making any money. I was in the hotel for 32 freaking days.
Mm.
Not that I minded the break necessarily, but you can't pay bills that way.
No, you can't. It's good downtime though.
Hey, I got the whole website built. Took
That's
me a
great
week to do the
news.
website.
Love to hear stuff like that. Let me see if I can
Involuntary
find
vacation.
this. Right.
Yeah, at least it wasn't the other kind of involuntary vacation, like jail.
Nope, still got the come and go as you please.
So let's see.
No, JD, it's amazing how you see the same thing that people make the argument about. How do you bring equity into court? And the way they talk, it's like the only thing that goes on in court is equity. It's the same thing they do when it comes to family court.
Right.
I had one lady, she was up against her ex. Well, I've challenged jurisdiction. I said, it don't do no good to challenge jurisdiction. Your ex gave it to him.
Right. Exactly. By petitioning.
That's, yeah, I said, the problem with you two is this. You think just because you didn't do something, they don't have jurisdiction. No, he gave them jurisdiction because you two can't act like adults and settle y'all's own contracts. The court has to step in and do it.
Yeah, it's really that simple.
Yeah, it really is that simple.
When you follow suit by getting an attorney and not able to, or not versed enough to combat that, then you fall prey to the jurisdiction.
Well, I
yourself.
mean, the thing about it too is you want, like, for me in my situation, the mother of my child hired an attorney, so she screwed herself, right? Because now you brought somebody in that doesn't have firsthand knowledge of the facts, and they're an infant just like you are. So now you can't speak, but also they can't speak for you. So what are we doing here? So whereas you would bring it yourself, we could actually have the conversation. I still wouldn't have it in front of the judge. We can do it privately, but you brought a lawyer and now you're in court. It's like, yeah, they're not even supposed to be here. You're a stranger, definitely not party to the contract.
And even in the church bylaws says you're not supposed to go to man's court. So this whole thing was a shenanigan.
And Al, he's right. You're a stranger. Ain't nobody as strange as you are.
I'll take that. Jesus was a stranger, you know. He said he was a stranger in this foreign land. I'm good.
So let me read something to you guys.
Brother.
Let me read something to you guys. Like for an example, right? So we're talking about an equity court. So I'll just read a little bit of what you might do coming into court. So you guys already heard me say this before. My name is granted to the court for future return with my interest. And then I would just say that again, that my name is granted to the court for future return with my interest. I appear only on special appearance as implied surety on behalf of the principal debtor. You guys heard me say that already. What's going to happen is the judge will object or say something like, well, this isn't a court of equity, right? Or this has nothing to do with that. We're here at family court. So that's when you would have to object, right? So I would object to any claim that this has no legal significance on the grounds the significance is not legal or at law, but equitable in a court of equity, where equitable rights are historically recognized. So, of course, due to the nature of this proceeding, the equitable rights are not cognizable here and therefore presents a conflict or variance of law. The conflict is equitable rights and the defenses are not cognizable at law, and the rights of my defense are purely equitable. So who will disclaim my trust, right? That's just a little piece of it. And that's something where you see I don't have a controversy with her over there. I'm not even talking to her. In fact, every time she speaks, I'm going to ignore it. I'm going to keep stating my position to the judge, to the court, really. I don't even care if the judge is listening. It's to the court, right? Because that's who we're making the trustee, the court. But again, that's just a little piece of it.
And anyway, I can't remember the maxim, but it's on my website, that equity, I know I'm not saying it right, but equity puts, the parties on equal footing. Well, where else do we hear that at? Equal protection under the law. If he says equity doesn't work here, then you just come back and say, wait a minute, Your Honor. I thought equal protection under the law was paramount.
Mm-hmm.
Well, if you're saying that there is no equal protection in this courtroom, then what kind of courtroom is it?
All right. And civilian due process that's an equitable maxim as well, right? When you're denied civilian due process, that's equity.
Well, due process is really one of the things I've learned studying law, and I didn't know this for years, is the term due process. When you really get down and analyze it at its simplest form, it's a contract term.
Right.
Did the parties agree to a contract fairly?
Right. Meeting of the minds.
Mm-hmm. If they didn't do it fairly, then somebody didn't receive due process.
Mm-hmm. So everything is about that's essentially what equity is. Everybody's asking the questions about, it's the morality. So it's the same thing. Morgan, when you're going to like, hey, she can see him whenever this and that. The problem is you're having that conversation with the judge. That's none of their business, right? That's not their business. The judge and you don't have to have that conversation. That's a conversation you have with her. You need to get them out of it first. So if you want to redo your contract, I would start there with her. Let her know that you want to make it something where she can see him more often, but on contract, right? Not just visitation type thing. Equal in some way, right? That's what you want. You want equity. So make it equal in some way where you're both getting enough time, because ultimately what's going to happen is it's your guys' contract. The only breach of contract is harm to the child. That's the only breach of contract in a situation like this. That's why you see guys, especially out here where I am, you'll see guys that have really done harm to the mother of their offspring, but end up getting full custody of the offspring while the mother's in the hospital because they beat the hell out of her, because it has nothing to do with the baby, right? So everything that you do, you have to understand that it's about the baby, but as it pertains to you two only. So if you have a contract, only you two can decide what changes in that contract. They can't help you decide that. The only reason that they can step in is if it's something where it's like, you made a contract, but that contract doesn't bode well with the law, right? So she has rights as well, and we have to make sure that that's being seen here. So if you're telling me that somebody has sole custody, one, we want to talk about ownership and title to our offspring. We don't want to talk about being custodians or guardians like the court is trying to be, right? Administrators. We're not that. We have full ownership, full title. That's what we want. Equitable title. You're raising your offspring, caring for your offspring. You gave birth, gave life. Your offspring is carrying your DNA, which is your intellectual property, right? So all those things matter more than a custody battle, and that's what needs to be. That's what needs to be done there. And with the church one, I honestly, that's something where sounds like there was just a lot of missteps for Al. So
did I tell you my theory on divorce cases?
I think maybe once before.
If a marriage license is a 3-party contract between the two spouses and the state, and the spouses, not the state, the spouses are the investors into a trust fund because of that license,
right?
And the state is the manager of that trust fund. Why not, instead of a divorce case, do an in rem action?
That's not a bad idea.
Now you can bring the state and the undisclosed trustees into the case. If you want to get your way in a divorce case, that'll do it.
It definitely will.
Because they're going to want you to go away as you're getting ready to expose everything.
Right. That's equity too, though, in rem action.
Yep. Unfortunately, I got a class I got to do right now at 2 o'clock, so I got to jump off. But thank you guys. I appreciate it. I'll be listening.
Yeah, in rem action is definitely an equity action.
Yes, it is. In rem, in personam. Always to get the job done. Like in equity, we like hearings. I'll do private process all the time, but I like going to a hearing to be heard. That's fine. I'll sit in here and talk with you. No big deal.
Yeah.
But that's what I meant by I don't play the name game. You know, I don't have to. We shouldn't even be in this court. So let me come here and tell you why. And again, there's paperwork too. Obviously, you can do it with paperwork. Never even have to show up to that. Just do it with the clerk, and then they'll drop the case. But
in a lot of ways, the clerk has more power than a judge.
Oh,
the
yeah.
clerk can dismiss the case just in the interest of justice.
Mm-hmm. That's why we send stuff to the clerk and the prosecutor, because they're the ones, right? The private banker prosecutor is the one bringing the action, and then the clerk is the banker. No person that has more power. To me, I think they do. They're more power than the judge or administrator. The clerk definitely does.
Well, the clerk, the reason why the clerk has more power is exactly what you're saying. Go into the file section and type in 7A dash. I think it's 7A 102 or 112.
Mm-hmm.
I found this in North Carolina. And it's investment of monies or securities that are in the hands of the clerk. And the very first thing on the list is obligations of the United States. Well, every U.S. citizen, it's an obligation of the United States.
Mm-hmm. That's exactly right.
I'm pretty sure you do enough digging in your own state, you'll find a similar code. Now, let's see if it's there.
Yeah, I see it here. 7A 112, investments of funds and clerks.
And if you look at it the way it's worded, we already know that the charging instrument's a negotiable instrument.
Right.
They're making you an offer.
Mm-hmm.
Now, that offer may be by force in criminal cases or civil cases, but they monetize these cases.
Absolutely. Anything you send in, any files you send in are securitized.
Yeah, they privatize, they securitize it on the private side. I heard a rumor, so it's just a rumor because I've not ever been able to experience it, that the judge actually keeps those monetary instruments in his office, in the safe.
Mm-hmm.
And if you ever get your hands on those, you'll see they sign the defendant's name on it. The straw man.
Oh, yeah.
Not Definitely. The trust.
I got a question about it.
Thank you. What's your
Go
question?
Ahead. So, if the charging instrument, correct? So can we accept it? Can we accept the offer and then apply stamp duty and then return it back to them for them to go ahead and close the matter?
Yes.
Do you know? But 99% of the people don't know how to do stamp duties. They think if they go get a postage stamp, that's stamp duties. And you got to go get the freaking tax stamp. Who gives those out? The IRS.
IRS, yeah.
Say that one more time. You have to get what now?
Tax stamp.
The tax stamp. You don't go to the post office to do stamp duties and think you're going to do it with postage stamps.
And the thing about it too is, we talk about improper process. The courts actually do accept with the postal stamps on them. And also, you're doing that so that they can't act like they didn't get it. So a lot of the times, stamp duties are supposed to be done through the IRS. That's what it's supposed to be done. But these banks and stuff don't know the difference either. So they're accepting these people's things, these instruments as well. So,
Yeah.
But you know what though? I'm one of the ones that was taught. I'm gonna say that again. I was the one that was taught that, you use it with the 10-cent stamp. I actually was what is it? Stamp duty? I think it was 18 something.
Yeah, the Stamp Duties Act. Yeah.
I looked on there and it was saying that any documents that you're gonna use use 10 cents.
Yeah, the longest running stamp is a 2-cent stamp, but
look at, let's see, tax PDF. I just shared it the other day.
Yeah, it's on there recently.
It's a tax. The definition of tax. Okay. If you go down to page stamp tax, a tax imposed by requiring the purchase of a revenue stamp that must be affixed to a legal document, such as a deed or a note, before the document can be recorded.
Right.
Now, if you look up the word stamp, because I posted that too, what is a stamp? An official mark or seal placed on a document, especially to indicate that a required tax, such as a duty or excise tax, has been paid. You don't go to the freaking post office to do that. Go to the freaking IRS or your state office. Hey, I got this negotiable instrument worth blah blah blah. I need to get the tax stamp. So
yeah, I'm looking for the office where I'm at. I don't know what the title of the office where I'm at is because, like I said,
it's your state revenue office.
Okay.
Yeah, they got their own tax office.
Mm-hmm. And they should have them in there.
Mm-hmm.
Because I know, like I said, I get it through with them postal stamps. So.
Yeah, I used to do those too. I've tried them. I didn't get no success with them. And you're right. Look, you are right. The other party may not know.
Right.
They may know enough, and they may accept it. But more than not, the people are not going to get victory because the people don't know.
And they're not going to get restitution. So when you're looking for recoupment, like I said, equity is about relief. So when you're looking for recoupment, redemption, restitution, through an equitable assignment, if you don't have the proper stamp duties on there, then that's what makes it tough too. So, I want people to do it right.
Same here.
Okay.
I would rather hurt your feelings and tell you you're wrong on what you're thinking, and then turn around and show you how to do it, so you do it right from here on out and you get more success.
Exactly.
Okay. Well, I definitely need to look into that. But have you guys ever heard of Amir L?
Yeah, I'm actually talking to him right now as we speak.
Okay, so
I don't know of him. I know I hear people talk about him. I gave up on gurus because I find most of them, not all of them. I can usually tell within a little bit if they know what they're talking about.
Yeah, I'm the same way, and that's why I said me and him have had we butt heads here and there, but he does have good information. Whoever his mentor is a really good one. So I can attest for that much.
So most of his process that he done did, I mean, I done seen a lot of results came out of that whole.
No, he does it right. The thing about it is he's not really telling what he's doing, so nobody can really judge whether or not it's right. But he gets results. He's pretty much like a 95% hit rate with his. By now, it's even higher. So
yeah, that is true. I mean, he doesn't really show you his processes.
No, he doesn't, and he charges out the ass for him. So
I guess that's where I'm different. I don't charge out the ass.
No, it's right there, conspicuous, right there on the thing where you look. So, and I mean, I know he's got 13,000 worth of process for only however much, but I know if you want him to be like the next friend for you, he's gonna charge you the arm and the leg. So, yeah, he actually lives out here with me. We live in Vegas. I'm pretty sure he's out here because we talk a lot. So, no, as far as exclusive equity goes, he's a great person to go to. Honestly, he is.
A lot of gurus will have some good information, some more than others.
Yeah, and I know he's another one that doesn't like to be referred to as a guru. So I mean, that's a good step in the right direction.
I use the term gurus generically because that's
Yeah, of course, I agree with you. But go ahead, man.
No. I was gonna say, yeah, he's the only one I see that really. Like, I don't follow a couple of them before, and it's like, they are right, but they're not really showing no success rate like what they did or nothing like that. He's the only one that I seen that was actually show. Okay, look, man, I did this right here because like tickets, he could do them all day, like he beating
those
them
are
all day.
easy.
But the thing is, like, I try to do the process because I even actually went to court and I ended up going to jail for 3 days.
So here's a question where I want to say about him. What's his belief on the name? Because I'm one of those that if you start with the opinion, that's my name, no matter how right you are from there, your process is going to be flawed.
His stance is right. The only way to actually to do it, you got to go in to change your name into the you have to separate your name. Like you can't go in there thinking that like he tells you your social security, your birth certificate, all of that, that's not you.
Separate from you. Yeah.
You have to know that. Like you have to put that in the air and say, this is not me.
Yeah. I know that you don't
but that's what I
want
to care for.
Look, you don't have to do a name change. If you was to get lucky enough, which not everybody can, get your footprint documents, you'll find out very quickly what your name might be or not be.
Yeah, we have all of our documentation. So he basically, in that separation, he says it's you're creating a whole new land of the state, right? So separate yourself from the birth certificate, the social security number altogether, create your own estate, new land of the state based off of the name correction, right? We don't do a name change as a correction.
I don't even think you need to do that. I mean, look.
Well, I mean,
your given name is what?
It's just the first name. The given name is just the one name. So
yeah, that's right.
So what you're doing though is now I have an exemplification document. That's 3 judges signing off on. So remember we were talking about the other day. You can't copyright something that everybody else has. So, but I'm the only person that has an exemplified document stating who I am. Right? And
now, Don, I wasn't talking about that book, but yes, that's in there too. If you look up the word tax in the files and the word stamp, they are from Black's Law Dictionary.
Yeah.
Okay, well, yeah, because I have to do that because what I did was I got a copy of my control instruments, and I was trying, and I ain't gonna even lie to you, I hold off because I was on the process of just writing this accepted for value to close and zero out the all in red and put the stamps on the back of it and then submit it to the judge. I was going to do it privately as a special deposit.
But you don't send that to the judge. That's not what you send to the judge, though. You send that to the clerk. Clerk is the bank, not the judge. The judge is the administrator.
The clerk does the investing. I just said go look at that 7A-120 or 112 or whatever it was.
Okay.
Yeah, the judge is not going to do anything but enter it into evidence, and all that means if you send it to the judge, the accept for value process, don't do that. I mean, bill of exchange is fine if you want to do it like that. Pay to the order of the court, like a grantee acceptance, you can do that. But if you send it to the judge, that's just going to mean that he has it for evidence when you go to court for your hearing. He can't deny the evidence because you have the stamp duties on it. So that covers both the front and the back of the paper as one document.
When you go to the IRS and get your tax stamp for that negotiable instrument value, yeah, you get that tax stamp, that thing's gonna disappear real fast.
Yeah, it will.
Okay, that's what I'm for the matter of fact, I'm for to do that so that I get a chance.
You got now because you gotta do the tax stamp before you record it. You put the tax stamp on it, and you need to learn how to properly endorse. And a lot of people don't even know how to do that because depending on what it is will depend on the type of endorsement.
Right. Exactly. And these are all orders to pay. If you have a warrant, that's an order to pay. So you know what to do with an order to pay. That you know how to endorse an order to pay. That's paid at the order of. It's a bill of exchange. But these other instruments are a little bit different. Depends on what they are. Most of them are orders to pay, though. Summonses are, And Pastor has talked about his debt instruments before as far as the citation goes. So, investment security.
I would be willing to say why most people don't own their house goes right back to that definition of tax stamp. They've never went and paid the tax
They
stamp
never
to
paid the
record it
tax.
on the deed.
Yeah, on the deed, literally. You have it, the deed, the warranty deed they give you. You put the tax stamps, you do stamp duties on that, send it to whoever it needs to go to.
Okay. One more question. So you know what a special deposit and all that kind of stuff, right? You familiar with that?
There's actually, I think in the law section, law on deposits.
Yeah, I've done special deposit before. Yeah, so I'm to be honest with you. Yeah, see, I learned that from Amir, but the thing is, it's not.
What did you learn? Yeah, because you can't. Here's the thing: you're thinking about a deposit like at the bank, and that's why you're confused. A special deposit, you can tender special deposit for performance, right? So I can tender special deposit, which means give specific direction on what I want you to do with this note or this instrument. That's tendering special deposit. So when I come in, and if we have a meeting of the minds, which creates two trustees, two beneficiaries on a document, that's a bilateral contract, right? So as trustees, we both have a duty to perform. And what I'm doing is I'm tendering special deposit for your performance on this note. That means take it and do what you're supposed to do with it. Here are the directions on what you're supposed to do. That's tendering special deposit.
Okay, so I did that, right? I made the clerk, chief clerk duty. I mean, what she is. I made her and the chief judge the trustee. I appointed them as the trustee. What I did was I got a $21 money order. I dressed it up pretty good, and then what I did was I did it on the special deposit slip and taped it on there, and then I sent it to them. They sent it back to me.
Okay, so what did you do when they sent it back to you?
Oh. Well, I was going to okay, so I was thinking to myself like that I had to do something wrong, and I didn't.
What did you do though?
I didn't do anything.
So you have to call a hearing. If they deny, that's your attempt to pay. You tender special deposit. That's legal tender that you gave. That's actually lawful money you gave. It's a money order.
Right.
So if you're denied payment, you call a hearing or go to your hearing to be exonerated as surety. All right. If you deny my payment, then that's discharge. I'm exonerated.
Yeah.
Okay.
Well, that's true too. But here's the other thing: just because you got done a Form 56 appointing them as fiduciary, that's an offer to contract. Everyone has the right to say no.
Yes, they do.
Yeah, but they have to give you a written one, correct?
No.
Oh, so okay. I thought that if you send them something, they're supposed to give you a statement saying that no, they don't want to do it because.
I mean, what you want, you want them to say yes or no. You need them to do that, right? You need to say, "Hey, I'm tendering special deposit for this special, this money order of however much." But
I'll tell you what you did wrong too. You've got to send true negotiable instruments, not these template negotiable instruments where people don't teach the right process. You got to, if you're sending money, you have to do it one of two ways: registered mail or through bank courier.
Yes, because that's technically securities fraud if you didn't send it the right way.
I did send it to registered mail.
Okay.
And then they sent me a letter back saying that, oh, listen, we can't take that. We need you only can send it through. It either got to be cash.
So they denied your payment. That's discharge. That's what they did. You just didn't go and hold them accountable for it. That's what happened. They denied your payment. You have to go in and, it's a plea of release at that point. So I'm exonerated as surety. I came in here. I tried to pay. Here's my proof that you denied it. I'm exonerated as surety. Issue your plea of release with them and then get out of there type thing. It's pretty much that fast.
All right, man. I ain't gonna lie, man. I'm glad I found you. And matter of fact, I'm gonna tell you how I end up finding this telegram. I was listening to King.
King Elbay.
Yeah, I was listening to him, and he was talking about, because I'm trying to figure out how to like get the MSO for my cars. I mean, I own the cars. I mean, well, I don't own.
MSO is house. MCO is car.
Oh, MCO. I'm sorry about that. So, so I was trying to figure out how to get the MCO, which I own the cars. I don't, you know what I'm saying, I don't have a lien on it. So, I was trying to get in contact with him to figure out, okay, if I don't have no liens on the car, how do I make the state take that to release the liens to actually give me the MS, to give me the original the certificate of original.
You need. Yep, we get it. You need the UCC 11. You need a certified copy that you don't have a lien, and then you just send that to the Secretary of State.
Yeah, well, I think people need to quit chasing the MCO. Quit trying to be owner.
That too.
If you want to be the liable party, continue trying to own everything.
Nah, I don't want to be the. Nah, I don't. You know, so I want to be the holder. Owners, I heard that's like a bad name. You don't want to own.
Registered agent or registered owner or
Yeah, I mean, look,
authorized
the state
user.
gets the MCO because whose name did you put on the document? You put the state's name. You put their EIN for that name called the social. The social ended up buying it, not you. So guess what? If they want to be the owner, start learning how to contract right and express it. Say, hey, I'm not liable for your ownership, but I retain my rights of use. Since you mandate I have to use these things, and since I have to manage your property, you need to start compensating me for my time.
Huh?
Yeah. I say it like this. I talk about it like, it's like they want you to be a state employee, right? So if I'm a state employee, for those of us that drive, it's like, I mean, I need to be paid for mileage. I need to be paid for gas. I need to be paid for, hours on the road. I need to be paid for a lot of stuff if I'm using your property, right? So, I mean, ultimately, it's more that than it is trying to be the owner of the vehicle. And again,
they want you to use the birth certificate. They want you to use the social. All that stuff is state property.
Right.
Okay. Yeah, man, you said something on that video that kind of sparked my interest. You was like, the only reason why we have the problems that we have is because we didn't accept the actual birth certificate, or I guess any instrument that they give you, you're supposed to accept it.
Well, you do a what's it called? A delivery receipt for warehouse goods. Hey, thank you. I got your property. Now, while it's being stored here, then you name your fee.
Right. Exactly. Got to look up the definition of warehouse receipt. I know he has it in here as well. I know Pastor.
Yeah, I seen that, but I was looking to see if he had like an affidavit for that.
I mean,
no, there's a template. Just look up delivery receipt for warehouse goods. It's out of California, but you really need to go into your state and look and see what they say. Mm-hmm. In North Carolina, there is no template. In North Carolina, they have a code that tells you as long as it has these things in it, it is a delivery receipt.
Right.
Okay. Yeah, I'm in Florida. I'm definitely in Florida. I don't know if it's. I stay in a place called Florida, but the county the county I'm staying in. Oh my God, man, they the worst, man. They don't know
Everybody says that.
Man, listen, you can go I used to go up there, and like what Amir used to say, like you need to go build a relationship with them and everything, man. I think I was going up there like maybe 3 or 4 times a day, and I'm talking to this lady, and I'm like, hey, listen, listen, you wouldn't want to hurt your brother, would you? And she was like, well, do you go to church? And she was like, yeah, I go to church and everything. I said, well, do you believe in the Bible? And she was like, yeah, I believe in the Bible. I said, well, what the Bible says? Do you follow the laws of the Bible? And she was like, yeah. I said, well, then how could you not give your brother information to not, to rectify the situation? Listen, if anything, if I did something wrong, I'm willing to pay at all costs, you know? And she was like, oh, really? I like, yeah, of course. I said, man, look, I got my checkbook here and I got I got a money order that's ready to go. All I just need to know is what I just want to know who I harm. And she's like, what do you mean? I say, in order for a crime to convict, I must have a corporate delicti, correct? And she was like, well, I don't know. I said, well, you need to know the law. I mean, this is your field, correct? I'm like, yeah, if you don't know, I mean, I'm here to help you research this stuff so you can be versed in the law. And yeah, man, I seem like I don't get nowhere with that.
Yeah, I understand. But no, you trust me, you ain't the only one that says the same thing. I hear people say that all the time. Well, this county's the worst. No, they all the same.
Yeah, I'm just trying to figure out how can I put them and make them be in compliance. Like, if you're not going, like I gave them a FOIA request, and they like, well, we don't deal with federal. Like, I see there's a whole bunch of federal stuff on here. We don't deal with that. I said, well, okay.
Well, you don't. Did you even look up the laws in your state on FOIA request? Because if you did, you would know you can't send it to the court.
Oh.
They don't have to honor a FOIA request.
Okay. Well, I didn't know that.
That's why I get on to people. Stop doing it because you heard somebody talk about it. When somebody talks about it, take notes. I don't care if it's me. I don't care if it's JD. Why do you think I tell you the source? I tell you, go read blah, blah, blah.
Right.
Go behind me. Go check. Then you know, because anything outside of knowledge is hearsay. And if you don't have the knowledge, you're never going to really reach true potential.
That's real. That's real. So who do I send this the FOIA requests to?
Well, that depends on what you're after.
Most of you the bonds, the oath of office.
Well, you got multiple places. If you're looking for the oath of office, go to the Secretary of State. Go to your county recorder. Find out where they're recorded at in the state. If you're trying to find out the bonds, who handles all those? Wouldn't that be the Treasury? Everything goes back to the Treasury when it comes money related. That's why you can actually do a FOIA request with the Social Security Administration and ask for transcripts, and they'll go all the way back to the beginning. Or do a FOIA request with the Treasury or the state Treasury. See, people are after information, but they're sending it to the wrong people and they're asking the wrong questions. You're never going to get the right answers until you start asking the right questions to the right people.
Okay.
See, I don't have no problem right now getting W-9s, because I don't go straight to the court. I went in North Carolina, they have the main office in the Capitol is, it's called the Administrative Office of the Courts. I went through the prompts. That's what sounded like the financial office. I had no problem getting a W-9. She even helped me get the one she didn't have. And then later told me, she said, well, if you have to do this again, just find out who does the billing and accounting office. They will, they have them. I said, oh, okay, thank you, ma'am. Who pays the bills for the county?
Oh, okay.
Now, do they call it a billing and accounting office in Florida? I don't know. But they all have a county that pays the bills.
Okay.
In every county. And just call them and say, hey, I need the W-9 for this court. Why you need that? Don't tell them it's because of a ticket. They'll never give it to you. You just tell them, say, look, I'm looking at issuing a bond, and I need to make sure I do all my tax filings correctly. Let's make it sound like something they're used to seeing.
Right, right.
Yeah, I've heard of people asking the prosecutor for the 1040 in court. I mean, it's not something I've ever done myself, so I wouldn't know. But I've
Yeah,
heard of
very
people
few
doing that.
people. Yeah, very few people get success in court or at the courthouse. But you start going to the right places, they'll give you the W-9.
Yeah. And then another thing too, right? Yes, I asked for who it was? I asked the clerk of court, right? I asked them for the oath for the oath for office. I mean their bonds. My bad. I asked them for their bonds, and it was like, well, this county they eliminated for all judicial officers. They don't have to have bonds. I'm like, what? That don't even sound right. And they got a statue and everything, dressed up pretty nice and everything. They gave me that form. I'm like, I said, well, how that even possible? Yeah,
Because they're not
somebody has.
judges. They're not judges. Well, they're administrators under Article 1 and Article 2. They're not under Article 3.
Hearing masters.
Yeah, they're up there administrating. They're not under the judiciary. Go look. I got a court case where it plainly tells you, talking about at the federal level, how the United States, the Supreme Court of the United States, does not have jurisdiction over legislative or administrative courts. Because why? They are created by Article 3, not Article 1 and Article 2. That's why people don't realize we have two Supreme Courts, one called the United States Supreme Court, one called the Supreme Court of the United States. One is by the Judiciary Act of 1789, one is by Article 3. People's got to start understanding who they're doing business with. Which, is it a legislative court? If it is, you know automatically, starting from there, it's under the power of the legislature. If it's an agency court, family court, IRS, traffic court, those are all under the executive branch. They're not judges; those are magistrates. They're in their ministerial capacity.
So you would go for redress to the legislator?
Well, that depends. If it's family court and if it's under the arm
statutes
of one of the agencies, it's under the executive branch. Because why? Delegation of powers doctrine. In other words, the legislatures had the power to do it. Remember the video I played the other day, Tim, where we were talking, where it's playing that Anton Scalia video, and they were talking about dog breeding, creating another hypothetical agency, right?
Yep.
So, well, what did Anton Scalia say? He talked about delegation of powers, giving more power to your competitor, the president. Well, all these agencies have their own court.
Yeah, because the attorney general will be under the governor, right?
Yes, that's the law firm for the governor.
And the attorney general is a signature to the cooperative agreement for Title 4D.
That's the attorney's office for the executive branch.
So you go to the governor's redress, I guess, outside of court anyway.
Attorney General.
Yeah,
no, I called the attorney general. I called the attorney general. They said they don't have. I don't know. Maybe I was mistaken. When I called them about it, they said they don't have jurisdiction over it. And I was like, well, that's odd because when I filed my federal writ against the judge who signed the order, magically it was her, the district attorney, and the attorney general et al. Versus me.
Well, you should have popped back to him and said, wait a minute, you don't have jurisdiction over this? How come your signature's on it? That means you trespassed on something.
Yeah. Well, I just
So Tim,
noticed whose signatures were on the other day.
yeah. So Tim, how'd things go today?
I went in front of the DA, the Title 4D attorney. I never went in front of the judge. It's to remain outstanding until January now. So I got another 90 days of an outstanding consent order.
They
And
didn't want you going in front of the judge. Gosh, wow.
I brought up the name. And he's like, well, do you have a social security card? I was like, I have a copy of the back of the social security card. I was like, and it says, I read it to him. I was like, it says it belongs to the Social Security Administration and they can ask for it back whenever they want it. I was like, it's just further proof that it doesn't belong to me. And he just gave me like this look, like he wasn't expecting that. It wasn't like a get the fuck out of here look. It was like, oh shit, I wasn't expecting that. But then he threw me a little curveball. He's like, where do you live? I was like, what do you mean, where do I live?
In my body.
In my body.
You should have said right then, like they just said, I'm living right here, right now. I believe I'll live in the body. Where do you live, Judge? Are you living here or are you living somewhere else? And this is just a hologram.
It wasn't the judge, it was the attorney.
It don't matter. Either one.
Yeah.
Don't matter.
Yeah.
That's the same
Judges
shit.
Judges are attorneys.
Yeah, they're all one and the same.
Right.
I don't
They
give
all
a fuck
are,
if they're wearing the robe or not. Seriously.
Yeah, we are a spirit that is housed in a body. So where do you actually live? In your body.
In the meat sack.
Yeah. But then after that, I brought up that his coworker at the last hearing, she misrepresented herself. She opened up saying she was on behalf of the Commonwealth, but then when I questioned that there wasn't a plaintiff, a real party of interest who has firsthand knowledge here, I was like, usually these matters either need to be postponed or dismissed altogether if they're not going to show up. And that's when she was like, oh, well, I'm a Title 4D attorney now. And under that contract, I can step into the shoes of the plaintiff. And I objected. I was like, I'm not a part of that contract. But then I just got that stenographer report back like last week. I've been asking for it since June because I appealed that order. But it was dismissed because it's an interlocutory order. But anyway, I got the stenographer report back, and I was going over the U.S. Child Support Enforcement website. It says Title 4D attorneys have no interest in either party, and that their only interest is the state's interest, and that there, by no means is there a attorney-client relationship between either party. And then I went to I started going through the cooperative agreement. I found the same language there, and it referred to the CFR. I went to the CFR, I found the same language there, so I printed all that out and highlighted it, and I started going over that with him. And he just got up and walked out, saying that he was going to get the judge to see if I was in that program or not. Pretty much, that's the only thing that saved me.
One of the things I would have asked when this attorney said she could step in for the plaintiff, I would have asked, great, what firsthand information do you have to handle that capacity? Right.
I didn't ask that. I just said that I wasn't a party to that contract she referenced, and I had a right to face my accuser, And then they tried to rebut it, saying that only applies to criminal matters. I'm like, really, it's all civil, it's just, I have a right to face my accuser in a civil matter too. But,
Yeah, no, I get what you're saying. And just, keep it in mind for the next time around, or the next time you see her, bring that up.
She's not going to be there again.
Get right up in her and say, hey, you said that you're going to be representing the plaintiff now. What firsthand information are you relying on to fulfill that capacity?
Yeah, I'm going to have to file a bar complaint because she's not going to show up again. Every contempt hearing has been a different DA, just popping up reading shit off the computer, and I keep rebutting whatever they're reading off the computer is hearsay. And I explained it was a different clerk today, and I was explaining to the clerk what I was talking to the attorney about because he was reading off something from that program saying that I wasn't I wasn't complying and that they couldn't get in touch with me. And I called, I found that out months ago. I called them to touch base about something, and we resolved that issue. And luckily for me, I had emails that I talked to this guy just last month and the month before, and we were in regular contact. So, you know, at least I had some firsthand documents to go against what he was saying, because that's the type of stuff they'll use to fuck you over. Oh, our computer says this, so that's what really matters. It's like that stuff's all wrong.
Well, this is the part where, like I've said many times before, anything and everything goes unquestioned, unrebutted, or unobjected to, considered to be consented to under true. So this is part of the reason why I say whenever they say whatever the fuck, you know, they made that claim. It's their burden to prove that claim. It's your burden to maintain that burden on them by asking the right questions.
Yeah.
Keep it on them, brother. They say it can't be done, make them prove it. They say it can be done, make them prove it. They say this, that, or the other, make them prove it. Period.
Yeah, I got everything in my hand is all I need, because I got their own statutes printed out. You know, the CFR. I got their cooperative agreement, which is their contract, so that's binding. And I have the order that's not compliant with those rules. You know what I mean? Aside from the proof of service and notice that's under appeal already at the Superior Court. I mean,
well, Tim,
I got them.
So your next court hearing's in January, right?
Well, for this, I'm hoping to hear about the Superior Court before that.
Well, the only reason I was saying is now you got time to get your legal files together, like we discussed. Go to Harrisburg and get them authenticated.
Oh, know what I found? The CFR website has a little logo on the top left-hand corner, and it lets you know that it's authentic from them. Hold on, let me see.
In other words,
exactly.
if it comes from the CFR, it's self-authenticating. Okay.
Exactly.
But not everything you have is self-authenticating.
Right.
Remember
Exactly. But this,
if it doesn't meet the rules of being
so pass.
Yeah, if it doesn't meet the rules, that's the documents you need to get authenticated.
I'm self-authenticating. I authenticate myself that I am me.
Yeah.
Half the time you don't even know who you are. Just ask the judge.
Well, that's a whole different story. I still authenticate that I am me. Just because I don't know who me is, I don't give a fuck.
That's not true. You signed that one paper, not me. So you don't even know who you are half the time.
That's true. There you go.
Hey, Tim, Tim, you were one of the ones asking about equity in the thing, right?
Oh, yeah. Yep.
So let's use the example. They asked you, because we already told you a quick way to do it, but let's use this example for they asked you where you live. Equity would say something like, you specially privately reside without the military jurisdiction of the United States, as defined by the Trading with the Enemies Act, and therefore privately reside within a non-military occupied private estate within the territorial jurisdiction of geographical republic of, I'm in Nevada, so I would say Nevada, right? Which I sometimes refer to as the Nevada Republic Free State. So special and private citizen, you know, and then that's when you hold private citizenship, and it's always of the republic.
But why make those claims, brother? Can you prove all that?
Absolutely.
How are you going to prove it?
I mean, it's simple. Like one, here, okay, so let's go. Let me do you one better. I don't have to, because I said I privately reside, right?
Okay, well, trust. But if you make a claim, bro, if you make a claim in court, it's your burden to prove that claim.
No, it's not. I have a private.
Yes, it is. Yes, it is, bro. Okay.
No. He who makes the claim has the burden of proof.
I'm not going to argue with you, bro. I've been through this. I've done a lot.
So what I'm telling you is I'm not arguing because this is what I do.
Onus probandi. He who makes the claim has the burden to prove it. Period.
Yes,
end of story.
But what I'm telling you is this: in 100 cases dealing with equity, if I ever had to do that, which I don't, because again, I'm never telling them where I live. I don't even get asked that question because I don't play the name game. We've already discussed that. In equity, I don't play the name game. I don't play the hair splitting. I don't do any of that. So that was just a version of what I would say as far as equity goes. And like if you were doing something for your quote unquote status or something like that. This is not for court. But, you know, if you felt like you needed to say something, because they're not going to ask you to prove that in court. They don't.
Well, what if they did,
Simple as
though?
that.
What if they did? Simple
They
as
wouldn't.
that.
Yeah.
How do you?
Yeah, I
Okay,
get.
you say they wouldn't. What if they did, bro?
So if
That's
they
all.
ask you to
Yeah.
prove it in court,
Okay.
then that's that's all something that you do with paperwork. Private paperwork done before court hearings. Means that when you go
Paperwork.
into
So you mean
court,
hearsay? Hearsay. So how is
no,
hearsay evidence
it's not
of something?
hearsay.
Yeah,
No,
it
it's
is.
not hearsay.
Yeah, it is. Yes, it
Affidavit
is.
backed
Anything
by
that's done in
what?
writing is hearsay. Everything that comes out of your mouth is hearsay, bro. Just because
No,
it's firsthand testimony
testimony.
from you to
Right.
everybody else, it's hearsay, bro.
Except for who? I make the court trustee. I don't make the judge trustee. So the court is administrative.
That's not the point, bro.
It is. I
You're
don't play the
missing the
name game.
point. Okay,
No,
I'm not
not.
going to argue with you.
Yeah, I mean, in this one you shouldn't, because I'm not hit or miss with this. I'm hit.
Yeah.
So this is not something I've ever had to prove.
I know what Popeye's getting at. And I
Yeah, me
what
too.
he's getting
I
at.
know what I know what we're getting at. We've had this discussion before, Papa. I'm telling you that the name game doesn't. I don't need to do that stuff though. Not everybody is equipped to do the name game either. So when I'm educating someone else on how to do it, it's not
What
about.
do you mean by the name game?
So when you're in there and you're saying, "Oh, well, do you have proof of this? Do you have proof of that?" The judge doesn't play that game either. You play that game with the judge if that's what you choose to do.
That's not what I asked. I asked, what do you mean by the name game?
So that's what I'm telling you. The name game is simple, right? So they come in there and they're saying something to you. Who the burden of proof is on the complainant. So if you're coming as plaintiff and you're saying something, then you have to prove everything you say, right? So one, I don't get to this portion that we're talking about because the judge is never going to ask me questions. I'm the one asking questions in court. I came here to ask questions. I only petitioned for a hearing to ask questions. But my private paperwork is simply that. There's no hearsay paperwork. It's not hearsay paperwork. It's not. Okay, because we're dealing with securities.
If that's what you want to believe, go for it, bro.
No, I don't turn in affidavits though. It's a security. It's money. I don't turn in affidavits. There's no hearsay anything. Because I'm not making a claim on the record. I'm turning in money. Right? That's a security. It needs to be drawn up as such. So my private paperwork, equity is private process done with the judge in chambers. Right? The only reason I'm talking to the clerk is because the clerk is co-surety or the bank, like Popeye and I were talking about earlier. She's the bank. So everything goes through her. I'm not going in court and playing that. I don't have to.
Well, you still didn't explain what you mean by the name game.
The name
you
game.
said
No,
absolutely. I'm sorry. I didn't mean for the middle of my sentence to interrupt the beginning of yours. Go ahead.
Yeah, the name game, because I guess I didn't explain it as far as
I guess you didn't understand what I just said. Thank you so much for allowing the middle of my sentence to interrupt the beginning of yours.
Yeah,
please go ahead, bro.
I'm going to interrupt you because I didn't finish. I didn't tell you what you wanted to hear, so let me interrupt you. So, as far as the name game goes, you're going into court. That's the first portion of it that I don't have to do. The second portion is, she's like, "What is your name?" Or I'm looking for whoever it is, and you're like, "Oh, that's not me." I don't do that.
Who said anything about saying, "Oh, that's not me"?
How would you go into court? We've already had this discussion, Papa.
No, obviously we haven't because you would not be saying that.
So how do you go into court?
Obviously, no. Wait, no. This is how it's handled. This is exactly how it's handled. They call the case. You say, "I'm here for that matter," like the attorneys do, and then they'll ask, "Are you such and such name?" Oh, I'm sorry. Again, I didn't mean for the middle of my sentence.
Yeah.
Go ahead. Go ahead.
Go ahead.
Okay. Thank you. So when they ask, "Are you such and such legal name?" you say, that is the name I am known to use. I understand that there's a controversy concerning that name. I'm here to meet with the claimant to see if I can settle this matter honorably with them. And then you shut the fuck up.
Yeah, I don't have to do any of that.
Okay, well, the fact of the matter is, you're doing a whole hell of a lot more, it seems like to me. You're spending
I'm not.
filling out paperwork and all this other stuff.
I'm filling out the paperwork they give me. Do you not get a summons? How do you know to go to court?
You got a summons, or did the name get a summons?
Do you get that or not?
I'm asking you, was it sent to you or the name?
So what the point is, it doesn't matter what name is on there. It's
Oh,
money.
okay.
It's a
So
security.
you're gonna play the name game now. So
No,
now
it
you're
doesn't
playing
matter
the
what
name
name is
game.
on. You just did it. You said, "Is that your name or not?" That's the name game.
Is
You
it?
literally just asked
Do
me,
you
"Is it
own the
being
name?
sent?" You just
Is it
asked
your
me, "Is it
name?
being?" Okay,
Now,
but listen, Popeye.
now,
It's not about that though, right? Because
Oh, it is, bro.
No, but listen though, because we just talked about this, okay? Me and Pastor just talked about this. They're sending you an order to pay. This is money. This is about securities. So when they send that to you, it's not your job to know what name is on it. It's your job to know how to endorse properly a security. I don't have to deal in court because I know how to deal with securities. You're going in court and playing that game that I'm talking about. I'm only going in there for exoneration or restitution. I'm not going into court and playing that game with them. Even in a criminal quote unquote criminal proceeding, I'm not going in there for that either. All proceedings are civil, right? So there's a claim against you. We already talked about this. We agreed on this. That means somebody has to have a claim against me. We agree where's that person, but I don't even have to go into court and deal with that. It's a security. Send it back to them, and then as Popeye was talking about with his debt instrument, the case is going to disappear before I ever have to touch court. That's equity, though. That is equity. So that's what I meant by the name game. I don't ever have to do any of that. We're not like, yes, the people that go in there, even with that in equity, I already described that. No, but not everybody was on the top. But I talked about what you do in equity if you have to go into a hearing. It's never going to be any of that. Where's the claim of that or anything like that. So that's all I was saying.
yeah. Popeye did a real good job on it. He went doing it the way he did it. If you have to go into court, I mean, I don't have a problem if you do, but I do also agree with Popeye. It's when they sent you that document with a name on it. I understand what you're saying. You're going to flip it over on the back. You're going to properly endorse it. You're going to send it back to them.
Right.
Okay, but whose name did they put on it? I mean, it's not yours. It's theirs.
No, that's the state entity.
So, yeah. And under law of agency, my personal opinion, under law of agency, based on that, I'm not supposed to send it back to the court. I'm supposed to send it to the principal and say, hey, handle your business.
Right.
Well, and the point of the matter
the
is,
Ditcher Act of 1939, it says the obligor has to produce the trustee. If that name is the obligor, who owns it? They do.
Right.
And the point of the matter is, too, since they own the name and they're charging the name, they're not charging the real man because they don't know who the real man is. They only know the name.
Exactly.
And they're expecting somebody to step up for that name. And that's how people hang themselves to begin with. But the reality is this. They are charging the name. They're basically charging themselves.
Exactly.
They're not charging the real man. That's the point that I was making, bro.
Well, we're making the same point then, because like I said, I just give it back to the United States. It's their business, not mine. I don't pay for your state transactions. That's on you. Handle it.
Yeah.
Well, it seems like you're just doing an awful lot to get there. When I just
I literally see. But you're walking in though. I don't even walk in there. They send that paper to the house, and again, I'm not the person they're sending it to, right? So I send it back, but I send it back endorsed properly so that they know how to handle it. Obligation in the United States, so you handle it as such. I don't do any extra work. I do less work, a lot less work.
Shoot, yeah, I tried to find me one of those rubber stamps to be able to put the endorsement on it.
Right.
So all I gotta do is take that stamp and go bloop. Mm-hmm. Because one of the things I went over in the proper endorsement class, it's 2 parts to the endorsement. I cannot single stamp that's big enough to fit that whole thing. I said the only thing you're gonna be able to do is that you're gonna have to print freaking labels.
Yeah, you are. It is labels, but I know the Office Max where I'm at, they were able to print out everything I needed on it because I have the grantor acceptance one, and then I have the presentation to the Treasury one, and I mean they fit on there.
What stamp are you talking about? A tax stamp or something else?
No. This is rubber stamp.
You can get rubber stamps made for whatever you want.
Yeah, I know you can, but when you when you look at the endorsement that's on the paperwork on that class I did, it's pretty big.
Yeah,
It's
it
like,
is. And you don't
it's
need
like,
everything that's on it either. That's why.
yeah, it's
Yeah, I
like,
didn't see that one.
I went and looked at a 3x4 rubber stamp, and I'm like, that's small. I'm gonna have to get the text of that.
Yeah, you got to change the font and stuff too. But because I have the one, I even had to take some of it out of it. The one because I don't need some of the fiscal agent stuff that it says on mine. I don't need any of that. So as long as it says presentation to the Treasury and things of that nature, then it works out.
Is that kind of like the same stamp that Smoking Baby was using for an endorsement?
I don't know.
I have no idea. Yeah, I don't know who that is.
I know who he is, but I don't pay attention to a lot of it anymore because the thing they push is the W-4 process, and I'm like, a lot of his teachings is right, as in the information. Yeah, he's not wrong. It's the process I disagree with, which I've made that known.
Right. Yeah.
Mhm.
I don't know. I don't pay attention to those things, so I don't know who that is. But
Do you have a
Hey,
picture?
JD,
Or
would you do me a favor, brother, and post or at least send me a example of how you're endorsing that? I'd just be curious to see what you're doing there.
yeah, I mean, I'll send you a picture of it, but it's really just pay to the order of, right? It's a bill of exchange. They send you an order, and then you just bill of exchange, pay to the order of, and send it back to the clerk.
Hey, Pastor, do you have an example of what your stamp would look like?
Well, yeah, I did. I got it in that class.
Okay.
Well, I guess I got to try to get that class.
Yeah. So I have a question where, going back to what Tim said when they asked him, where do you live? Can you also say, I live in the private, and they say, prove it? Say, no, it's private. Are you coming to me in the private? If you're coming to me in the private, I'll explain it to you. But if you're not, then it's private. We're in the public.
You could do it like that, and because it's really just about, like I said, the trust now established, right? So I declare that these proceedings are damaging to my rights in the private, right? So you're asking me all these questions, I object. Right, and I declare that these proceedings are damaging to my rights in the private. So if you want to have this conversation in chambers, or you want to move it to a court where they can hear my equitable, status here, then we can do that. But here in this court, we're not talking about anything.
Yeah, exactly. That's how you can thwart any kind of further conversation. If you say that you live in the private, say, no, I'm not discussing it in the public. It's private. Yeah. That's the whole thing. So if you want to discuss privately where I live, then let's go. If not, no, you have no right to that.
Yeah, why would you want to discuss your privates in public?
Yeah, exactly.
Right.
Yeah, exactly.
Discussing privates in public gets you in trouble and puts you on a list.
Right?
Exactly right.
They'll call you a predator.
Yeah. So that's what
you got to register every place you go.
Right. And then in equity, that's what you do. You're basically telling them, if you guys want to do this right, we can take it to a court.
Yeah, take off your robe, dude.
Yeah,
we can talk.
Yeah, we can have this heard properly, but you're going to have to also come back. We're giving it's opportunity to cure, right? In equity, you give opportunity to cure as well. So we're going to give the prosecutor or complainant the opportunity to bring an actual injured party into this as well. So let's back out of this deal. We'll give you a shot to make a proper complaint, right, in the private. Yeah. And then we'll speak about it that way. But if you can't do that, then there's no reason for us to even do this. And most of the time, they just dismiss the case anyway. So.
Okay, so I'm going to go ahead and stop the recording, Pastor. It's going to go to you, and I know Tim wants to listen to it.
I think the audio may go to me, but the video will go to you. Send me the video.
Oh, well? Okay. All right, cool. Let me stop it. Stop.